Yes.
Your Honor.
State wishes to call the case.
Yes, thank you, Your Honor. This is State versus Matthew Mayfield Johnson, Jr., 14C42686. Defense counsel Gale Riedr is present with the defendant who is out of custody, Doug Hanson, for the state. Your Honor, this is the time and date we had set up for a change of plea in this matter. It is my expectation the defendant will be entering no contest pleas to counts 1 and 2 of the indictment, and we have a stipulated agreement. UCJ offer worksheets have been provided to counsel and the court, and I can go over that at the appropriate time. I will say that this has taken extensive negotiations. I think this is a good resolution to this matter. I think all parties are ready to proceed.
Ms. Riedr.
Thank you, Your Honor. If I may approach, I have for the court a petition to enter pleas of no contest to counts 1 and 2, executed by Mr. Johnson after reading with counsel this morning, together with a notice of suspension.
Okay. Mr. Johnson, would you go ahead and stand up, please? Mr. Johnson, how are you this morning?
Fine.
Okay. Mr. Johnson, I have before me a plea petition. Did you go through that with your lawyer?
Yes, ma'am.
Did you understand the things your lawyer has told you?
Yes, ma'am.
Do you understand that if you give up your right to a trial, all that will be left is for me to impose this sentence, which is, in fact, a downward departure?
Yes, ma'am.
Has anyone made threats or promises to get you to do that today?
No.
To the charge of delivery of oxycodone within 1,000 feet of a school as an 8B with a presumptive 35 to 40 months, knowing that there's a downward departure, how do you plead?
No contest.
Okay. And count 2, promoting prostitution as an 8B, presumptive 35 to 40 months with a downward departure, pursuant to agreement, how do you plead?
No contest.
Okay. Go ahead and have a seat, and what the state needs to do is fill in some facts for you.
Thank you, Your Honor. If this had gone to trial, the state would produce evidence that on or about May 16th of 2014, at a location at the Shiloh Inn of 3304 Market Street, Northeast, room number 419, which is within Marion County, the defendant was in a hotel room with his wife, Jessica Johnson. There had been an agreement between Ms. Johnson and an undercover officer to engage in sex for money. The officers had arrested her. The defendant was in a closet, had come out, and indicated that he was there. The officers then talked with him. It was discovered through information provided by Ms. Johnson and the defendant after Miranda rights that he was there assisting her in the promotion of the prostitution. She had indicated to officers that she shared the money and the proceeds of the prostitution with her husband, which is the defendant. Further inquiry on the cell phone of the defendant was found text messages that were consistent with that. Also text messages in regards to the oxycodone, where he was trying to sell 50 pills of the oxy to a friend named Nick for $200. And that was found on the defendant's cell phone. He indicated that the text messages were accurate. We still don't know who Nick is, but that he had it was constructive delivery in that location based on the fact that he still had the cash. The oxy pills were found in the room in his wife's purse. There's a valid prescription for the defendant, but he, of course, can't sell those, and that's what he was attempting to do. So the totality of circumstances would show that he was actually delivering oxycodone, a constructive delivery, on or about that time. The text message was the day before, as you heard in the motion. I think that would be sufficient for those pleas. In regards to being in 1,000 feet of a school, it was within 1,000 feet of Hoover Elementary School within this county.
All right. Ms. Riedr, I understand that there's been an agreement between the parties. Is there anything else that you'd like to tell me?
At this time, Your Honor, we stipulate that if the state were to put on evidence without any evidence from the defense, that those are the facts that the state would be able to prove. No, Your Honor, this is as Mr. Hanson has said, this resolution is the result of a number of different negotiated possibilities, and we are asking the court to impose the sentence as stipulated by the parties.
Certainly. All right. Mr. Johnson, yes. Go ahead and stand up. I've heard a lot about this case through the motions. Is there anything you'd like to tell me
I don't even know what to say about this. I've been fighting it for 14 months, and I stand here and tell you that, it's not true, but I'm at a position where I feel like I don't have help, so I have to do what's right for my kids. If I didn't have kids, I would see this through trial, but being that I'm a father and I love my kids and my wife, I would like to have an opportunity to show that I'm not the person that they made me out to be, the officers. I understand Mr. Hanson's job as a district attorney, and also my lawyer Gale Riedr's job as my private counsel, but at the same time, I was never given an actual chance to show evidence, and I further would like to appeal it with using my rights. So that's all I have to say.
Okay, you signed this document, and in this document, you are stipulating to a plea. Okay, what I hear you saying is that you want this deal, and that's called an Alford plea. Basically, you want the deal. You're pleading no contest because you want the deal. The state's willing to come off of a presumptive prison sentence so that you can get a chance to show that you're a different man than these charges would show. And you're entering this plea knowing what the state's evidence would be, and you're saying, I'm entering a no contest plea because if I presented no evidence, the state would be able to make their case. Okay. And that what I hear you saying is that you're entering that plea in part because you believe that it's in your best interest to enter a plea.
Yes.
Is that right?
Yes, ma'am.
Okay. And you're pleading no contest in order to get the deal.
Yes, ma'am.
Okay. Now, at the bottom of this thing that you signed, this plea petition, it says, I understand that by entering my plea, I am giving up all right of appeal. Okay. So, unless the sentence imposed exceeds the maximum allowed by law, which it doesn't, basically, you're giving up your right to appeal. So, you're taking the deal, and you're agreeing with the state, that's it. I'm going to show I'm a different man. I'm going to look after my children. I'm going to take this downward departure so I don't go to prison, which potentially could happen if I went to trial. So I'm going to plead no contest, and they're going to come out of the presumptive sentence and ask the court, why stipulation to come out of a presumptive prison sentence that you might face if you went to trial? You might be found not guilty at trial, But you might end up facing a presumptive prison sentence. So, here's the question. You're signing a document as part of your plea that you're giving up all rights of appeal. You're taking the deal, and that's that.
And that's not what Ms. Rieder just explained to me in the hallway. I literally asked her if I could appeal within 30 days, and she told me yes.
And if I may, Your Honor?
Sure.
I think that the statement in the plea petition is a bit too literal. Under current law, a person is entitled to file a claim for appeal, or a notice of appeal, if they can state a colorable claim for the appeal. Now, I know when you enter a plea, whether it's guilty or no contest, those rights can be very limited. But if the public defender's office, after consultation with Mr. Johnson, can find a colorable claim for appeal, then a notice of appeal could be filed, notwithstanding what the plea petition says. That's my understanding of current law. So while he has limited appeal
I have rights, no such thing as limited.
Some appeal.
Erase that from your memory. I got limited nothing. I got rights, and I'm choosing to exercise them, which I did when I wrote her an email.
The plea petition is designed to make sure that people understand things are going to be very limited.
Things are going to be very limited. Okay, we see. Because I'm sure choosing to exercise my right.
I know that there are, of course, post-conviction rights that the defendant has that are separate from appeal rights. That's something that...
But what they didn't tell me is that I had to file a notice of appeal first in order to get those
there are
rights.
Claims that the defendant has against his prior counsel.
Kerry Weiland.
To file appeals or PCR on that, I don't
right.
know. But
He
do
Kerry Weiland again.
Limited rights in regards to appealing this conviction.
Why the deep breath, Mr. Hanson? It's a unlawful sentence, and I'm appealing it.
We're not objecting to that.
You can't, because you know deep down inside you screwed me over, and I want justice.
You've heard counsel explain to you that there are narrow rights of appeal. And by this says that I'm giving up all rights of appeal to a higher court unless I can show that
and I can
the sentence
and
is
I will,
unconstitutional,
and it is unconstitutional.
Or it exceeds the maximum allowed.
Not the maximum allowed, but it is unconstitutional.
Further understand that a notice of appeal must be filed within 30 days, and that the notice of appeal must be sent to the district attorney, the trial court administrator, and the trial court transcript coordinator.
Which is on his way.
I understand that if I apply for an attorney and I am indigent, an attorney may be appointed for me to represent me on appeal.
Yeah, hey. God's working in mysterious ways. Yes, I do.
With that, I'll go back and accept your pleas to delivery of oxycodone within 1,000 feet and promoting prostitution. As I outlined before, I'll again accept the statement of facts that the state outlined before. I'll consider this a stipulated agreement. As I said before, I'll enter the guilty pleas for the record. As I said before.
I'm sorry, just make sure it's clear there was no contest plea.
Oh, I'm sorry. Yeah. I'll enter the no contest plea.
Don't try to be Mr. Nice Guy now, Mr. Hanson. You done me so wrong, nothing you can do will change my outlook on you.
That you'd like